Hi all, welcome today to an exciting session on legal, particularly wills, trust, and succession planning. I'm Hemant, founder and CEO of INRI. I am personally excited to be hosting this session and inviting a special guest, Ms. Kamala Naganan. And before we get into details, I would like to also introduce INRI today, the host of this event. So here's a brief timeline on how we've grown so far in the last 2 years. We started in 2023 and we began with investments as a major product. Now we have investments and taxes and then more. Subsequently, we've added many products, and we've been able to garner a lot of love and interest around the world from NRIs. And today we are excited to be launching legal as a part of our product suite. And I am really excited to be doing this as well as having this launch with an educational session with one of the lawyers. Let me introduce Ms. Kamla. She has amazed me in the past few months around her knowledge and expertise in law area. She's a managing partner of Arna Law. She's based in Bangalore. She works with multiple families in India on the succession planning and generational wealth transfer issues. This includes advising on wills, trust, and cross-border transactions and structuring in business succession. Apart from work, she is also a trained meditator and a champion of mediated settlements, especially in the family succession space. She has worked with some of the largest business families on resolving their disputes through mediation. Um, Kamla, welcome today.
Thank you, Hemant. Thank you. It's a pleasure to be here. Thank you all for joining us.
Yes. So we'll be beginning. You can share, your video. Sorry, the screen, and then we can begin.
Super. Firstly, thank you all for joining us on a Sunday morning. Really appreciate the enthusiasm of all of you here. Let's start by introducing myself and the organization, Arna Law. We're a boutique law practice, and we have been based in India. We have offices in Mumbai, Delhi, as well as Bangalore. I personally am based in Bangalore. We work with individuals, promoters, as well as companies on both their domestic and international business needs. We are India based lawyers, but we see that over a period of time, a lot of Indian promoters are looking at global businesses, strategic acquisitions, and the Indian Desi has come of age where they want to spread their wings, travel all over the world, find the right opportunities, both in terms of strategic business acquisitions as well as potential job opportunities, right? And that's really the very niche space that we're working in and trying to help resolve those issues. I'd like to start by sharing my screen. Can you see the screen? Great. So the topic today that Hemant really wanted me to talk about as part of this launch of the legal chapter for INRI was looking at primarily estate planning, but with a focus on wills and how to transfer wealth. I think just to give you some idea of, we spend our whole lives building our organizations, building that nest egg for our families. But at the end of it, if we are not able to ensure that we're passing it on to the next generation in a manner that is responsible, in a manner that is easy for them, all our life's work is, a waste. And therefore, what's very important for us to look at while we are growing our nest eggs as well as our retirement funds and keeping, these amounts aside for the various goals that the family has is estate planning, because it's the advanced management of an individual's assets in the event of their demise, and making sure that very clear instructions are given in case of these eventualities is really what estate planning is all about, right? So purpose of this estate planning initiative of anybody is firstly control, right? You want to be able to be clear on what happens to your assets. And you want to make sure that it devolves onto your next generation at the right time when they're able to handle it in a manner that they are responsible. Second, I think it's very important for you to be able to have the clarity of deciding who gets what and what you would like to do with your life's work. I think third is very important of making sure that in case you have minor children, there is a guardianship to them if there were an issue. The other angle of the guardianship issue that is now coming up is people are living longer, but there are a lot of issues of health and mental health, especially, which are now coming to fore. So, importance of having guardianship regulations even for the individual has become an issue, because in the US, what we're seeing is that if you don't have it, you have to go to the courts, and then the court appoints a guardian, right? And that guardian will be an absolute stranger or might be a distant relative who will come forward, but they really don't know what you have in mind. So I think it's very important for you to have a very clear arrangement of who the guardian will be in case you were to be infirm, in case your spouse were to be infirm. The next important aspect is the executor appointment. Now, who is an executor is something I'll come to further down, but I think an executor appointed somebody who you trust, who will understand what you want done, is extremely, extremely important. The fifth reason why you should do it is because it gives you peace of mind to say that you've built your whole life working hard for your family, and that you don't have to worry if something were to happen to either you or your spouse. Everybody's taken care of. Sometimes you have older parents who you support, in-laws you support, right? The larger extended family. But making sure that you have that peace of mind is very important. I think the next reason why you do it is because these are all dynamic documents, right? They have to be looked at once in 5 years because circumstances change, life situations change. So this is not a one-time exercise. We recommend that wills are looked at once in 4 years. You update it, especially in terms of, caregiving responsibilities, your children and their life situation, your individual health and situation, assets bought and sold. Finally, and the most important, is it prevents disputes. I think, we all see that families get disintegrated for not having the right set of advisors who are able to then bring about that peaceful resolution. And so, why would you want a dispute in the first place? If you're able to make sure that you're very clear and articulate in all your documents and everything is uniform to say who gets what, right? I think in India, what we see in most business families, it's very clear the children end up joining the business. But I think that's changing now, right? A lot of them are going abroad, settling down, getting educations out of India. And so they don't really necessarily want to come back to India. In which case, there is a huge issue of what happens to the assets remaining in India. And then what happens to the child? How does the child in any way get supported or claim those assets once they are not in the country anymore? Because if they're living in another jurisdiction, they don't have access to funds in terms of understanding what your bank accounts are, who you bank with, who your investment advisor is. So I think making sure we prevent these disputes and ensuring that the asset goes to the right people is motivation enough to keep estate planning as a top agenda item looked at least once in 5 years. Right? I think the key components that one looks at, especially from a US perspective, and this presentation is going to be a combination of both US requirements as well as India requirements. We at Arnalov strongly suggest having two wills, one with all your Indian assets, one with your US assets. And the reason we suggest that is because invariably the regulations in each country are very different along with regard to succession, right? So while the US and India are global tax jurisdictions, if you are resident in either country, what's important to keep in mind is firstly, you have very clear, specific instructions for what happens to your assets in the US such that it's enforceable if something were to happen to you. And the same reason is why you need to have a separate will for India, because if you were to use your US will in India, you would have to get it uh, passed through a succession process, right? Which is probate, succession certificate, and then finally that becomes a very, very long process. But if you have a registered will with very clearly identified assets, you don't have to firstly expose your US assets to the authorities in India, and you don't have to expose your Indian assets to the authorities in the US. So chances of even tax claims and issues around what the estate duty will be can be mitigated by making sure you have two very clear demarcated succession plans. Right? We can integrate it. We can make sure that they're all up to date, but it's highly recommended to have very clear two separate documents. So the key components, right, are firstly the will, secondly the power of attorney, which is a document that gives authority to a particular individual to act on your behalf were there to be an issue. Third is the living will, right? We're seeing more and more in the US. Of course, it's a norm. In India, a living will is not legal, but a lot of people are openly talking about it to say, I don't know resuscitation. In case there are health conditions where they don't want to go to hospital, making it clear at what line the individual does not want to pursue a medical line of treatment. And unless these things are written down, the next generation is not going to be able to execute it. And suppose you have two children and they have two very distinct opinions on this. I think having the will written down, especially in terms of living will and what you'd want done, is extremely vital to prevent, again, disputes and discord in the family. I think under US regulations, what's very important is also a medical decision maker, because in case there were to be an issue, under HIPAA regulations, who is the person going to be spoken to by the doctors or the hospital? Because I think under US regulations, there are very, very clear demarcations to say that they will not speak unless they have the authority to do so. So if you are lucid, that's fine. The doctors can speak to you or your spouse in terms of the line of treatment. But if not, making a clear decision on who that decision maker in terms of medical data is very important. Second is also a declaration of a guardian in case you have minor children, as well as a declaration of a guardian in case you were to be incapacitated. What's also covered right now in both jurisdictions is funeral details, because again, some people are practicing religiously, some people are not. The details of the kind of ceremony they want, the kind whether they want a burial, they want a cremation, whether they want it to be done in India, whether they want it to be done in the US, right? All these things are to be put down. And I think it really helps, because then it gives the children clarity as to what they'd want done, right? In most families, these are issues that are not spoken about. Indian families just sweep it under the carpet and just think, that it happens. I can give you an example of a family where the father passed away suddenly, and the children didn't even know whether there was a will. And it was after the 13th day ceremony that the uncle came and handed the will over. And everybody was till then kept guessing as to what would happen. Not that the children wanted anything, but knowing would have really helped reduce the tension and stress on the children, because the investment advisor did not know, the family lawyer did not know, the chartered accountant did not know, the spouse did not know. So I'll come to why it is important, especially from an Indian perspective, to ensure that you have all this in place. But it's extremely vital to ensure that you put some regulations and have that difficult conversation with your children once you are clear in your mind. It doesn't have to be done again and again, but I think one conversation is important to have it. Other important thing that is now very common is body donations, as well as specific donation of organs. Again, there have been instances where they've said that they want to donate their body for research. In such cases, it's only a spoken word to say an uncle or a nephew, right? But the children wanted to actually perform the ceremony. So in which case, what does one do? Right? So again, having this written down makes it clear to say what they want to do. Also in India, there are a lot of donations of the eyes, right? Because that can be done easily. It can be done at home. A lot of people, if they're in hospital, want to donate organs. So I think it's important for you to be clear whether you want to do it or not, and if you want to do it, what you want done. I think what's also important is to look at it from perspective of tax planning, and therefore trusts, where it's a combination of a revocable living trust as well as a pour-over will, is something that I'll talk about further down. It's something that you could think about. This is a fantastic way of making sure under US regulations, you're able to put away a large chunk of money. They're also able to ensure that you're able to, avoid to a large extent the estate duties, right? The next is businesses, right? Anyone who has a business, I think a lot of promoters in India are completely short sighted because they don't believe in succession, right? And this is where family businesses are disintegrating because they've not put in a clear line of succession. And two, they have not brought in professional managers. So if you would want your business to have a succession plan, it's important to have that discussion with the people who are going to succeed you, to clearly enumerate what you want done. Prenuptial agreements are not common in India, and they're also not enforceable in India. There is a push towards this just because the amount of wealth that is being generated in India is now significant, and they don't want to have issues. But I think in the US it's a very common practice, especially if it's a second marriage for both parties and there are children involved, so that there is clarity on who gets what assets and who can claim what assets. Uh, I don't know if you've seen the latest divorce of this famous actress and her husband. Forget his name. Keith Urban and uh, Nicole Kidman. So they were able to finish their divorce in under 6 months. The reason they did that is because they had very separate assets, right? There was no jointly held asset. And therefore that prevented, and both of them were in second marriages, right? And both of them had children. So I think what's important is for you to have that very clear arrangement of what you want done. And if you are entering into a marriage, then have separate assets such that then there's no confusion. Charity is also a very, very important cause for a lot of families. I think philanthropy is only growing. And earlier it used to be done quietly by families. Now they want to set up trusts, want to make sure that they give very consciously, give to specific purposes. And so charitable trusts are possible to be set in both jurisdictions. Finally, I think making sure that you have that red file for all passwords, social media accounts, bank accounts linked to email accounts, email IDs, right? All this is something that completely gets lost. Even your laptop or personal computer or cell phone passwords, right? All this is very, very important because they're all linked to all our, assets, both in terms of liquid assets in accounts as well as in financial assets. And in India, from a perspective, right now, you have to get a PID number. Now, in order to pay even simple things like your taxes, you need an OTP, right? Now, if that OTP is linked to your phone and nobody has access to that phone, then there is a problem. So making sure that all this is put in a red file and kept somewhere such that somebody knows is important. Finally, I think a lot of entrepreneurs are investing in cryptocurrencies. And again, making sure that crypto wallet is accessible, giving them the password, understanding what you want done with it is very important. The last point I'd like to bring up is the whole retirement plan and life insurance policy. So under US laws, both these do not come under the will unless specifically put down, right? So under US laws, retirement plans have beneficiaries. Insurance policies have beneficiaries. So we've got to make sure that we align your insurance policy and your retirement plan with the beneficiaries such that your will is not contra to what that nominee is, right? Also, please make sure your retirement plans have nominees. Please speak to the nominee and let them know what you want done. And also for the insurance policy, it's the same. So I'd now like to come back to the main topic, which is what is a will, right? This is a legal document which is in writing with the intention to clearly state what is it that you want done with your assets post your demise, right? Any person who's of sound mind, who is not a minor, and who has the ability to enter into a contract, right? And has property should make a will. It's absolutely essential from an Indian perspective to make a will, because very often if you don't do it, if you India has a succession under each of your personal laws. So Muslim law is one, Hindu law is one, Christian law is one, Parsi law is one, Sikh law is another, right? So invariably, if you don't have a will, your succession will be based on your religious personal law, which means you have no control over it. It just goes according to that. So if you are a Hindu, what will end up happening is all your successors will get a share in it, right? So it'll be your wife and your children will all have equal shares. Now, if there were to be elder children, and if you have a wife, and if for whatever reason there's a dispute between your children, your wife is going to be stuck. Therefore, it's very important for you to put down very clearly who you want in the will to be the successor. In most cases, what we recommend is after the individual, it goes to the spouse, the surviving spouse. And it's only after the surviving spouse that we recommend it going to the children. So I'm now going to from an India perspective first, just to give you some idea of what the regulations here are. Right? So, like you can see, the framework is very clear, right? Each of the religions have a law, and these laws are very, very old. Under each of the laws, you have sub-laws. So if you look at this table, Hindus, Buddhists, Sikhs, Jain, all come under Hindu succession, right? And there is a Hindu Indian Succession Act as well as the Hindu Succession Act. So therefore, what we need to do is very clearly understand what the religious practice of the individual is and then decide. Now, an interesting twist to this is if you say, listen, I'm not a practicing anything, you will still go back to Hindu succession law, even if you're not practicing, right? So it doesn't matter whether you're a practicing Hindu, Muslim, Christian, Parsi, Jew. It's very clear that succession happens only on the basis of your religion, right? Now, what are the various components of the will, right? First, it must be a written document. You must have very clearly identified who the legatees or the beneficiaries of that will are, right? It must have an executor. Now, an executor is an individual who is responsible, who you have faith in, who you have spoken to, and who's agreed to take on the responsibility of the executor. He should be aware of where the will is, with whom you've left it, right? And the last date of the will, which is registered. He should also agree that he's the one who's going to come in to do what needs to be done, right? So if you have an executor for an Indian will sitting in the US, it's of no use. He will find it very difficult to come here, deal with the bank accounts, deal with the sub-registrars, deal with the lawyers, and get things moving. So if you have an Indian will, please make sure that the individual is based in India and able to do what you want them to do. Same thing for the US, right? You need to have an executor. Now, the beneficiaries of the will can also be the executors of the will. But again, you've got to let them know that this is what you want done, right? And so having those conversations are very important. Date and signature on the will is absolutely necessary. You also need to have witnesses very clearly being present when you sign the will, right? Also, you should have a clear distribution plan for each of your beneficiaries, and that can be based on whatever you want, right? If it is assets which you have inherited, then it comes under Hindu Succession Act. Or if it's, say, an ancestral property, right, which came under an HUF, then it's very clear that your children can claim it. But if it is self-acquired property or if it is self-acquired financial assets, then the distribution can be exactly according to the plan. Now, there is a way around it if you have ancestral property where we can have a family settlement. But again, that's a very nuanced thing and has to be done before something happens to you. So happy to speak to anyone who has those issues because it's a more tailor-made approach that we'll have to look at. Right? Now, for registration, right, we recommend that all wills firstly be put on stamp paper, right? While it is not mandatory, I think it's very important to do it. Wills can also be executed on plain paper, but having it on stamp paper is good. Second, registration. Though registration is not mandatory under the Indian Registration Act, we highly recommend it because, one, if you have any physical property in the form of either an apartment or a house or a land, The sub-registrar will make the legatee's life miserable because he will say, go get a probate on the will and only then come back. But if it's a registered instrument, he will immediately do the khata transfer and change the name from you to whoever is the beneficiary. The only three jurisdictions which absolutely require probate are Mumbai, Calcutta, and Chennai. Everywhere else in India, you do not need to probate the will if you have a registered will. Right? Now,
What? I'm sorry. What does probate mean?
Probate means going to the court and showing the will, filing a document before the court to say that you are the beneficiaries of the will and you are the actual successors of the individual, right? Otherwise, basically it's to, if somebody is going to claim, they want to know what is your relationship with the person who has passed on, right? Just saying you're his son or you're his daughter is not good enough. Therefore, the court gives you this succession certificate. Very clearly, it will be whoever are the successors, right, as per the will. Now, it can be larger families, like in some cases, it can be the mother who is still alive, right? It can be grandparents, it can be in-laws, but very clearly demarcating who are the individuals who are going to succeed the property, right, from the individual has to be clearly earmarked. The will does it, but Bombay, Calcutta, and Chennai are all presidency states, right? So they came under the British. So that rule has continued and they've not changed it. So that's why these particular places need it. So the benefits of having the will registered is it reduces disputes. It ensures that all your physical property gets transferred without too much of an issue. It increases authenticity of documents, and it also provides easy access, especially in the case of banks, right? Banks can make your life miserable. So there's a family I know in Bangalore who had, who's, one of the members of the family. Oh, God. Oh, God. This timed out.
Can I share for you?
Can you hear me?
Yeah, we can hear you.
Okay. Sorry, it got timed out for some reason. And you can see me as well, right?
Yeah. I think Zoom is on. Your screen, I mean, the presentation is now, we're not able to see. You can send me
Okay.
the presentation. I can move for you.
Okay. No, I'm not able to get any accounts. Okay, you're sending it to you, Hemant.
Yeah.
I'm sorry about that.
You might want to stop sharing the screen while you're sending.
No, my screen has completely frozen for whatever reason.
Can you stop sharing? I think Zoom is
Yeah.
working.
Okay, so I'm very grateful that Zoom is working. But I can keep talking and Hemant, I'm just forwarding it to you.
Yeah, sure.
Yeah.
In the meanwhile, there were a few questions on the estate planning or transfer of assets to the surviving spouse and heir in US.
Yes.
Do you want to go through them or should I take it?
Sure. If you can read the question, then I'm happy to answer it because I'm sorry I can't see the screen.
No worries. So RK asked a question because for non-resident aliens, the limit of estate transfer exempt estate tax is around $60,000. So he wanted to understand if there are any strategies we can implement to avoid paying huge amount of taxes on the non-exempt estate or property.
Yeah, so I think what's very important for us to remember is the fact that at the end of the day, right, when you are thinking about succession planning, what's very important to look at is not what your worth is today. but what your worth of the estate will be at the time of your demise. And therefore, you've got to start planning from now what you want it to be in terms of what the total estate value will be. And so putting in place the structures now by talking to a tax consultant as well as a lawyer can help. I think one of the things you can look at is this revocable living trust, right? There are various other trusts or structures available in the US where you can very easily put assets in from now, such that you're able to then make sure that you're, as the value of those assets grow, you've thought about it and it'll be out of the purview of estate duty. For example, right, if you look at say an investment that you've made right now, the minute that you're able to put it through a trust and invest it through a trust, it's still your money. It's being invested through the trust. You're then able to ensure that the gain on it goes to the trust, right? And so this is how you have to do succession planning. It cannot be spur of the moment. You really have to think about the long term as to say what your ultimate estate value will be, how much of it you want to use for yourself and for your retirement, and how much of it you want to use for philanthropy, and how much of it you want to give to your children. And only then, right, structure it. So I'm happy to have these discussions separately so that we can think about, your present life situation and then tailor make it to that. So I think, what are the essential elements of a valid will are that it must be written down, that the legatees must be clearly identified, right? Every will must have an executor, date and signature, details of the beneficiaries, and the distribution plan. Can we move to the next slide, please? Right, I just spoke about stamp duty. We can move to the next, as well as registration and the importance of registration. We can move to the next. It also ensures confidentiality. So there's a way in which I talked about that the revocable living trust, right? The LRT. Now, what some people do is that a will is ultimately a right? When you register it, what ends up happening is it becomes a public document. Therefore, what people in the US are doing is that they make a general will, which is very, very simple, which does not give details of the assets. They make a irrevocable living trust, and that has the provisions and wishes, right? And what they then do is called a pour over will, which is the bare bones will. So therefore, the bare bones will only states what absolutely must be stated, and everything else gets put down into the revocable living trust, right? So this is how they work around this. So ensuring that if there are certain confidential information that you do not want to be shared, then having this structure will always help, right? The process is very simple. You go to the sub-registrar's offices, you have two witnesses, and you have a proof of identity, you make a nominal payment. And in India now, the sub-registrar's offices are very clear. They have appointments. Only on the basis of the appointment do you have to go. So it's very, very civilized. Can we move to the next one, please? Next slide. Right. Notarization is an option, both in the US as well as in India. It's not mandatory. But in some instances, when there is a US will that needs to be enforced here, then they'll ask for apostling, going to the embassy and getting those approvals. So having two separate wills again is important if you have assets in both jurisdictions. Can we move to the next slide? I think what's very important is also for you all to have conversations with your parents if they are in India to say what do they want done with their assets, and make sure that you can align that, right, with your ultimate succession plan, and ensure that there's a way or mechanism by which you're able to then use those funds in a systematic manner. Like we know families that just because there was no clarity have lost a lot of property and things because they're like, listen, I'm so busy in the US, I don't have the time to come and sort out issues in India. And so they're like, just let go of the property or let go of those financial instruments. Now that's just lying with the bank. And whenever you come, you'll need multiple rounds of documentation and proof to get it done. So I think, to prevent this leak of funds, it's important.
I think we lost you, Kamal.
I think the audio went out for some
Yeah,
reason.
we didn't hear the last sentence. No, we can't hear you.
While the audio situation with Kamala is getting fixed, I see a lot of questions regarding help with tax planning and their estate planning. I'm a CPA from California. I live in Central Valley, California. We can definitely help you with tax planning. And Hemant has shared our website where you can actually go and read about our tax planning services that we provide. So,
Yeah.
I
Can
have
you,
a quick
sorry,
question,
can you,
guys.
sorry, I was the one who initiated the conversation. This is RK. Do you also help with structuring the estate plan in a way with the tax deferral strategies?
yes, our lawyers, Kamala, she would be able to help you plan the legal side of it, to put it in on paper how the trust would work and the conditions and terms around the trust. And we can help you understand how the tax implications of it would work based on your current assets and investments and how it would translate whether you are a US citizen or you are a non-resident alien. We can help you understand tax implications on both sides.
So I have a quick question on that.
Okay,
So
thanks.
Kamala, are you able to speak? Like, just curious.
Yes, I can hear you. Can you hear
Okay,
me now?
okay,
Yeah,
we
yeah.
can continue. Sorry,
Yeah,
Kamala.
let's continue the presentation, finish it off, and then we'll take more questions.
We can take questions later.
Yeah.
Super. Can we move to the next slide, please, Hemant?
Yeah.
Right. So witnesses are absolutely mandatory, whether the US will or the India will. So there are two key witnesses that are required. They have to be present while the testator is signing. They should be over the age of 18 and of sound mind. And the role is to, if there were to be a dispute, then ensure that they're able to go to court and say that they were witnesses. Right? Move to the next slide, please. It is highly recommended not to have any of the beneficiaries as the witnesses of the will. Hi, Hemant. Can you hear me? Can we move to
Yes,
the next?
we can still hear you. You can continue.
Okay, super. Can we move to the next slide, please? Right. So we're now going to look at, wills from a US perspective. I think, there are different kinds of wills that come into play in the US. First is, of course, just a simple, straightforward will, very, simple finances, not too many properties. Then there is the joint will, right? Where two people, say a husband and wife, say that they want one will. We don't recommend it in India. We recommend separate wills for each individual. The third is the living will, which again does not talk about property or money, but gives instructions on medical care. And in case there are any issues with regard to, dementia or loss of memory or physical ailments, and you're not able to look after yourself, then what you want done. I think the fourth one is a non-cupulative will, where it is made verbally. This is usually done, by military servicemen or Marines, and it has a time constraint after a specificity of time. And then there's finally the testamentary trusts as part of the will, where you can either create a trust before, or you can draft a trust deed and annex it to the will, and it gets incorporated on the demise of the individual, or on certain specific milestones being reached, or you can specify what that is, right? So testamentary wills are an option. They're a great way of tax planning, because then you can make sure that there is no taxes that can be imposed on this on the legatees. Right. So in the US, wills are allowed to be registered to ensure that people know where it is. I think it's primarily for that purpose, to indicate where the will can be found. And a will does not need to be notarized, right? No state requires that the testator has to register it. But in certain cases where they want to make sure that people are able to retrieve the will, they go ahead and register the will. Can you move to the next slide, please? Now, as I told you, the two reasons for doing this is to mitigate interstate issues, that is to prevent any disputes were to happen if someone were to pass away and nobody would be able to find the will, and to ensure discoverability so that everybody knows where the will is, right? Can we move to the next slide, please? Right. Now, I'm going to talk about a list of ancillary documents that are highly recommended in the US, and then I can take your questions. I think first is this key medical directive. This should be a part of the list of documents that have to be created along with the will, because this gives them key medical directives as well as financial directives with regard to the health of the individual, and ensures that the individual's will is respected and decisions are made, especially on the case of, if you have certain religious practices that you follow, you want certain methodologies of things, not, like a trial vaccine, which was maybe used with a particular cow serum or whatever, right? So enumerating this is very helpful. It's standard practice to do it. Second is, of course, the power of attorney to ensure that somebody can manage your estate if there were to be issues of incapacity. The third is the medical POA, which clearly gives the healthcare caring decisions on, if someone has dementia, right? When is the right time to decide they should be moved to a care home? What is the kind of care home that should be, right? How far should that be? In which state should it be, right? These are all important questions and decisions that should be taken. And so making sure that you have one person who will be in consultation with the lawyers as well as the medical staff to take that decision along with your children is very important. It can be your child, but you've got to nominate who it is you want, right? Finally, the whole thing of living wills, right? It's very, very important to have this down. In the US, especially with how things are going right now, a lot of people are very confused on, what is right to life. And with things becoming more and more conservative, you will want to have a very, very clear, watertight will and a living will declaring when, if terminally you have an issue, should they maybe turn off the ventilator or stop treatment, right? If it's an irreversible condition, when is the right time to say, okay, this is it? Also, under the Health Insurance Portability and Accountability Act, doctors have a huge responsibility to only speak about the matter to a designated person in writing, or to the individual or the spouse, right? In some cases, they have been called upon for talking to children without the authority of the patient. So therefore, it's very important under HIPAA to make sure that you grant access of medical information to your children. Also, this will help them because if their children, like if there are genetic diseases or there are genetic issues, right, they'll have access to your medical records, and then they can go back in terms of treatment protocols and diagnosis for the next generation. Can we move to the next slide, please? Again, guardianship of minors is very, very important in cross-border marriages. We've seen a lot of issues where, people from India have moved to the US because the spouse is a US citizen, they have children, and then there's a divorce, and then she comes back, right? What happens to the children, right? Who has legal guardianship? And how do you then ensure that you have rights of visitation? So it's very, very important to put this down very clearly. In India, the rule is very clear, where if it is a child below the age of 18, and especially if it's a girl child, the courts do give preference to the mother. In the US, it is the same, but in some cases, especially in California and New York, they're pretty open to making sure that the father can also get access if they see that he has the ability to look after them in terms of time, energy, effort. Right. So again, making sure that the guardian's role is clear. Are you going to pay them? What happens to the educational requirements of the children? Are you providing them with housing? What is the general welfare for them? Right. And it ends when the child turns 18 or the court revokes the guardianship. Right. In some cases, when there are children who have special needs, there has to be, again, very clear demarcation of what happens to the child, what are the needs, who will be the guardian, and again, making decisions for the child, because if something were to happen to the parents, then there has to be a clear understanding of what happens, right? Even things like, a child who has autism, right? What happens to that child? after the parents? What happens to the assets? When do they get control of it? Do they even get control of it? All this can be put down if you have a very clear guardianship and plan put down in writing. Because then the courts will not decide. If you don't have this in writing, then you're at the mercy of the courts, because then the courts will call up the petition and then take a decision. Can we move to the next slide, please? We've had instances here where the child has been moved to India for protection, and because the grandparents are here, and then there have been issues. So I think making sure having you be clear about it and putting it in writing is very important. Guardianship in terms of medical needs for the individual, again, I mentioned, in terms of making sure there's proxy, healthcare, there's a medical power of attorney given to somebody, making sure all the medical records are kept in one place and are accessible and available to an individual, right? Treatment decisions of end of life care as well as medical consent for it should also be clearly written down. Can we move to the next slide, please? Right. So I was talking about pour over wills, and someone asked me about the whole irrevocable will trust, right? So the pour over will is a type of will where what you do is you keep it bare bones, right? You have a will clearly stating out what you want done, but it does not list the assets. So upon your demise, any asset not already owned by your trust, right, are poured into this. So it provides a safety net to ensure that any assets that you've left behind get put in this. What is also good is that if you have a trust where all your assets are kept, and if this is just a very simple, plain vanilla will, you have the privacy of ensuring that it doesn't become a public document, because at the end of it, a will is a public document. Right. Now,
Hi, Kamla. I think we lost you again. We cannot hear you. Kamla, can you hear me?
insurance.
Okay. Mm,
I think our audio went out from him.
yeah. Hello, Kamla, can you hear us?
I think she froze completely.
Yeah, seems
Of any inheritance tax. So the minute you do this eyelet, you will have no inheritance tax or estate duty on this. But again, this has to be done now while you are buying the insurance, so that it's very, very clear what you want done, right? Can we move to the next slide, please? So I'm going on reiterating that what's very important is you have to be strategic in your succession planning. You have to not look at what your wealth is right now. You've got to look at what your wealth is at the time of your demise and make sure that you work backwards, right? You've got to be specific. You've got to be strategic. You have to communicate your intentions. You've got to make sure that you clarify the treatment of your debt and your liability. You have to provide information on your personal belongings, right? I think what happens is in India, you have a lot of silver, you have a lot of gold, you don't put it, saris, things of value that you collect over time, paintings, but there is no clarity. And please understand that one person's precious items are another person's garbage, right? So you need to make sure that you have very clear instructions given, right? Next slide, please. I think in conclusion, I'm happy to take questions. I see that there are a few questions in the chat box. So Hemant, how would you like me to do it?
Yeah, before we jump on to questions, I know we are at time, so I want to share this briefly. As I mentioned earlier, like we are launching our product with Arna Law on succession, which is includes wills, trust, and probate. Here, I will share this link also in the chat. So here is an opportunity to get this what we discussed today planned out or talked out, because a lot of things requires consultation. So we highly recommend, if you are in that space questioning things, this is an opportunity to get that done with Kamla and her team. This includes consultation as well as it has the pricing. I would say that the pricing is very reasonable to begin with. We are actually starting this with the early bird offer. You wouldn't find this anywhere, the best price. And feel free to go over the process. We have detailed out the items that what we will include. We will also be including more options later in the future, like around legal paperwork. And now I think there are few more questions which included tax. So I also want to mention that we do have a tax practice that includes both US and India. Under US, we offer US tax filing as well as planning. Nilesh, who is present today, he's our Chief Tax Officer based out of California. So we will be working in consultation with both of them as we require from your end, and can get things done for you. Also,
Hemant,
Right.
the
So I think
the
maybe what
pricing
I'll
that
do is
you
I'll start by answering the questions going up. I think MJ has asked to say if we were to make a US and also India estate planning, who would we work with? Right. So you would work with us, MJ. We'd be your one point of contact. That is INRI. And we will help you both with the India related aspects as well as the US related aspects on both the wills as well as the structuring in terms of tax.
MJ, you were gonna say something. Sorry.
the pricing includes the estate planning for both US and India or just the US?
so this is a starting pricing. I want to mention that obviously it depends on the complexity that you have. The scope of the pricing is mentioned here. If you go here and see the plans, like there is a standard will which includes some items, and then there is a consultation that is part of it. But I believe most people may have custom requirements, and that could be a pricing dependent on your requirements.
Okay.
I think
Do you
what's
honor?
important for us to understand is what your requirements are before being able to give you a quote on it. Right? This is
Yeah.
a general quote we have here, but we're happy to take this offline to answer specific questions.
Yeah.
And towards that end, we have a 15-minute, call that we're able to have with each of you, clearly understanding what your requirements are, and then tailor making a proposal
Yeah.
for you.
So what I recommend is like you don't have to pay upfront any amount. You can start your application by clicking on this button, start application, and once you submit your requirements, we will connect you with the Kamla's team, and there would be, as she said, there would be a 15-minute complimentary call to understand if there is a fit, and if that makes sense to proceed ahead, and that's how we will work this upon.
So there's a question from Nikhil Jain. Do you also help with NRIs who are getting inheritance from Indian parents? Absolutely, we do. A large part of our practice is identifying these pain points and trying to resolve it. But again, I will not be able to answer specific questions here because of paucity of time. But we're very happy to get on that 15-minute call with you to answer the questions. Right.
Where is your office coming?
Bangalore.
Okay.
Sadashiv Nagar.
Okay.
Yeah. I think Kriti Sharma has raised her hand. Go ahead, madam. You
I
can.
from my wife's laptop. So I have a quick question. So so in case I were to move to back to India, and I need to do an estate planning, who will be the trustee in that case? Because if I am living in foreign, that for trust would be considered as foreign trust, and then all the CK rules will be applied for me.
Again, this is too personal a question. You will have to give me more details for me to help you identify, but there are ways of doing it. There are trusteeship companies who are now available both in India and US who will be able to do it.
I see. Okay. Yeah. Thank you.
Thanks. One question is if you have two wills, one in the US, one in India, how does it legally work from US and India perspective? It's very clear. Only your US assets will be in the US will, India assets will be in your India will, and there should be harmony in both of them as to what you want to do. If we were to make US and also India estate planning, how do we work? I've already answered that. Is there an option to book a one-on-one consultation? Absolutely, there is. Please reach out to us. And like you can see, we are giving you a 15-minute time slot to firstly understand what the requirement is. right? And if you're planning to move back to India, absolutely, please do have a call with us. We are seeing that there are a lot of issues around shares, right? Shares which you might have received as part of an ESOP pool, or shares which are vested or have not yet been vested. It's important for you to be very clear on this, because FEMA regulations make it very clear that if you were to sell this, that money has to come back to India if you're an Indian tax resident. If you're not an Indian tax resident, and if you're still a US tax resident, we can structure it in a manner that before you leave the US, you've taken care of the FEMA requirements and made sure that you've safeguarded this, and that that pool will continue to grow. Second, we can also make sure that you can build into it a succession plan for your children, such that you don't have to worry about FEMA regulations in India once you come back to India and become a tax paying resident in India. So I think it's very important for you to please have this discussion. We recently had an issue like this, and the gentleman moved back to India. His son is now going to the US to study, but he's stuck. He cannot liquidate that, because once he liquidates it, it has to come back to India under FEMA regulations to go back to pay his school fees, right? So if there are issues like this, please do reach out. Subraman has a question. Go ahead, sir.
Hi. So the same rules and laws apply between Canada and India too?
With regard to moving back to India,
Yeah.
what is the specific?
So like the bills and whatever you are saying between US, most of the presentation is between US and how it works with India, right? So
Yeah.
my question is like, it must be the same, but just I want to double confirm on that.
It's similar, but we'll again have to look at your specific questions and answer on Canadian law, and happy to get on a call with you to understand that requirement and come to an understanding of how we can help you.
Okay.
The recording of this session, I don't think will be shared, but I'm happy to share this presentation with you all in case you want to go through it. I think we have, someone says, I have a MetLife legal plan where estate planning and wills trust is covered. Do you honor that plan? No, we are not part of the MetLife legal plan. If you would want to, interact with us, happy to do it through the INRI platform. Right. Do you have a US CPA who can help with estate planning, trust, etc. for New Jersey? Absolutely. We're able to work across the US to help identify issues and resolve it. Will wills and laws differ in different states in the US? Yes, wills do differ for different states in the US. There's a general federal law, and then with regard to taxes, there are also local laws. So when we are drafting your plan, we will have to look at both the taxation angle as well as your succession angle to be able to guide you. Where does the Indian assets will need to be registered in India? So if the US citizen does not have an Indian address, it doesn't matter if you can register it in any part of India. Unlike the US, we have one framework for succession, and the will is applicable all over India. Is a will created in US considered valid in India? It is considered valid in India, but in order for it to be enforced, you will need to probate it, which is a long process, anywhere between 12 to 15 months, 12 to 18 months at the minimum. Would you be able to cover advantages of a Wyoming LLC as well as in this call? Not really, sir, but happy to speak to you offline with regard to it. Do we have a US CPA who can help with estate planning or wills and trusts? I think Nilesh has answered it. Can we meet the lawyers in India to make an estate plan for US assets, especially for non-resident aliens for estate planning? Absolutely. Happy to get on a call. And if you are in India, please do reach out. My details are available on this presentation, which Hemant will be circulating. Would US citizens' assets in India require a will in India? No. We highly recommend a US citizen's assets in India be in a will in India, but a US citizen's assets in the US be in a will in the US, right? So it depends on whether you've inherited it or self-acquired it. We're happy to, again, speak to understand more. Multiple assets like real estate, cash, something else, all can be mentioned in one will. Yes, you don't have to have separate wills for separate asset classes. What's important to know is where the location of the asset is, right? Be it physical asset or financial asset. And then we can plan it around it. I think the probate question I've answered. Any further questions?
I think there's one last.
Hi,
Okay.
sorry. I do have one question. Are the rules for will or estate planning any different for, say, like US citizen versus folks that are on green cards for India?
No, it's the same.
Thank you.
Whether you're a citizen or a non-citizen, whether you're a tax resident or not, the wills is the regulation around succession is based on personal laws.
Okay.
So
And sorry, yeah, and I did put another question, which I think you answered partially with somebody else's asking the same question. But just an extended portion of that question was, if you create two separate wills, one for US, say, and one for India, then can US not question that and or either disregard whatever you have for India, uh, or vice versa, just because you're keeping two things separate, which is cleaner, but can US not mandate or force you to include everything in one?
but you're declaring it. If you're able to declare it in your tax returns to say that you've inherited this under an Indian law, under an Indian will, you don't have a problem. So whoever is, suppose it's you have made two wills, your children should declare it in their IRS returns, very clearly highlighting which of the assets are in the US and what they have inherited from India.
Got it. Thank you.
Thank you.
Extended question to the last one. So the thing is that if we declare what we get from our parents, the assets, so do we pay the taxes on that one every year, or at the time when we sell those assets?
It depends on what kind of what you're doing with the asset. If you've inherited from your parents, then you have to pay an inheritance tax. But again, we can, what's important under inheritance is you have that conversation with your parents and we structure it in a manner that you can ensure that you don't end up putting it under the estate taxes in the US, right? There's a manner in which we can structure it immediately before you inherit it, and it can continue to remain as an asset in your parents' name, right? But I need to understand a little bit further before I'm able to advise you.
Yeah, thank you. Thank you.
Great. Thank you all very much. Really appreciate the time. Happy to, have those one-on-one conversations to understand more clearly what the requirement is and work together. Right? Good evening.
Yeah.
Thank you, Hemant.
Yeah, thank you, Kamla. Before we close, I want to extend my sincere thanks to Kamla today. I think it was a eye opener for me as well, to know a lot about succession wills, particularly. We'll be doing more such webinars on legal, extending to trust and inheritance too. Today we covered most of it on wills, and we'll be doing more such sessions in the coming months. So stay tuned for that. I also want to, I've just shared quick resources on the chat. So there are two things. One is estate planning and one is tax planning. So there are two different products for it. If you have questions overlapping them, just feel free to email us at contact@GoNRI and we'll be happy to guide you accordingly. On US tax, we do have our products, and this is the current offer that we have. You could get $100 off on US tax planning. We help plan your year-round tax strategies, including filing, tax loss harvesting, as well. And we also cover a lot of advanced tax strategies that could help you really save taxes, thousands of dollars or more. Post that, there are a few upcoming workshops that we're gonna do in this coming month. This is the one which is coming next. Will be in person, starting at Palo Alto in California, and then the second one at Milpitas. So we'll be covering building wealth for tech professionals, and this is the idea is like most of us are high income earners in the US, particularly in Bay Area, and must think beyond W2, how to manage, our wealth and keep most of it and not give away in taxes. This will be hosted by Nilesh and myself. And Nilesh, as I mentioned, is a registered CPA in the US state of California. He'll be available in person for the event. Yeah. So yeah, any questions, just feel free to email us and or either use those links to connect directly with Kamla or Nilesh.
Can you please share this presentation?
So we'll be sharing the recording after the.
Oh, you will. Okay.
Yeah.
Thank you.
Thank you. Any parting notes, Kamla or Nilesh, you want to share?
The easiest way to get started with these things, I see a lot of questions again on how, or like, do I need this or do I need that? The easiest way and the most effective way would be to schedule a call with Kamla for 15 minutes. As we said, it's a free call. There is no harm, there is no liability. You don't even, but all you have to do is register or send an email to contact@goinri, and we will be able to get you in touch with either Kamla or me on any question that you would have. Uh, I would suggest that you ask me tax related questions and legal questions to Kamla about bills and trust. But that would be the best way to get started to understand what you really need. And we can help you understand as well, because sometimes we think, oh, we need a really elaborate process and things in place, but in most cases we'll advise you the most optimum solution for your situation rather than implementing everything under the sun. So it would be cost effective for you as well to set up a call with us and understand what you really need before you go ahead and start doing things.
Yeah. Thank you all for your patience. I think what's most important is for you to plan ahead, right? We spend all our lives planning for various milestones in our life, but we don't think of this one aspect, which is inevitable. But I think doing it wisely, doing it carefully, and spending some time on thinking about it, right, before you actually do it, based on what your personal circumstances are, your life goals are, what your family thinks, where your children are, is important. So please do spend some time thinking about it before we have that conversation, because a lot of it is what you want done. And very often I see that when I ask those questions, people are like, I've never thought about it. So I think it's important to think about it. I'm very happy to give you a list of questions to think about and ponder. And invariably, when I give those questions, people forget. People don't come back to me for 6 months because there's just so much that they need to think about, right? So begin by at least having that call and thinking about this, and then everything will flow. It's not very difficult, but you've got to spend some time on it. Yeah. Thank you. Good evening.
Thank you. Thank you, everyone.
Thank you, guys.
Have a good weekend.